Hey, everybody, what a great way to spend a Wednesday lunchtime on federal civil procedure before trial. Now, we're going to be mining federal golden nuggets. There's my avatar right there. You can see it. That's my publishing company says that I've got to have an avatar. But my grandson says I look like Papa Smurf. So let's get going. Golden nuggets. We're going to talk today about brand new cases that have been decided within the last year and some within the last week, U.S. Supreme Court, Ninth Circuit, and right from your home district. So and these PowerPoint slides are available to you in that regard. Oh my goodness, what a terrible slide. Well, this is mining. You'll forgive me, I'm from California, and so we have the gold rush out here. And so what we're going to be doing is looking at these cases. Hey, in 1988, the U.S. Supreme Court decided Hazelwood versus Kohlmeyer. That was a case in which a high school principal censored the high school paper, The Spectrum, and sure enough, it went to the U.S. Supreme Court on First Amendment issues. Now, I teach a First Amendment course in an undergraduate journalism department, and for over 20 years, I taught the case, and then something happened. I was on something we can't even remember being on. I was on a plane. And I had, leaving Boston on a stopover in St. Louis, I had the row all to myself. And then the stopover occurred and someone sat next to me. Oh man. And then he was one of those ones with the elbow in your ribs and he wanted to talk to me. Are you like me? I don't want to talk on a plane. So I kind of ignored him. I ignored him the whole flight. Even at the meal, I didn't talk. I was just saying, I can't talk. And then something happened. It was a gold. It was a nugget of gold. It was hidden. I didn't know who he was. And then I asked him as we were about to land, hey, what do you do? He got all excited. He said, I'm a high school principal. Guess what? His name was Gene Reynolds. He was the high school principal at Hazelwood High School for the case I had taught for almost 20 years. And now I couldn't get enough of them. So today we're going to be looking for those hidden nuggets like the person sitting next to you. My publisher said I had to do this, but forgive me. Let's go right to it. So these are our mining tools. You have Title 28, you have the federal rules of civil procedure, and you have your local rules. Now we have this particular book that I published as well. It's three volumes, it's online, it gets updated every 2 weeks with current awareness. But as Mark Twain said, once you put it down, you can't pick it up. It's 3 volumes, let's get to it. Here it is, everybody. This is our pyramid. In federal court, you always start with subject matter jurisdiction. You'll get your way to personal jurisdiction and venue, and only after you deal with those threshold issues do you even deal with the merits. Louis Brandeis, the great Supreme Court justice, said, the most important thing federal judges do is not doing. Jurisdiction first. All right, let's get going. Let's go to our first gold nugget. If we're going to talk about federal jurisdiction, let's look at a case from this last term from the Supreme Court. What is jurisdictional? The Fort Bend case. Let's look at the facts. It's a Title VII case brought without the plaintiff identifying a particular claim in an EEOC filing. As you know, in Title VII litigation, you normally have to exhaust your remedies. No one raised this, went on appeal, got remanded, and then some smart lawyer said, hey, this is a failure to exhaust, and they filed a motion to dismiss on jurisdictional grounds. They said there's no waiver for lack of jurisdiction, no matter how long the delay. The question, everyone, is it jurisdictional? So if I were Alex Trebek, I'd be telling you with music that it's not jurisdictional. The Supreme Court held that exhaustion of remedies is a claim processing rule. It's not jurisdictional. Take a look at the cases cited in this screen. Look at the one from Judge Seabright. If you have an argument that something is not in commerce that's required for a trademark case, that's not jurisdictional. It's not jurisdictional if someone says the number of employees in a Title VII case, or was the copyright registered. These are non-jurisdictional defects. So a time limit is normally not jurisdictional. If the claim is missing an element, like there's no ERISA plan, that's not jurisdictional. And Fort Bend tells us exhaustion is generally not jurisdictional unless Congress says it is. All right, everybody. So here is our screen. The fact of the matter is that this is very important as we talk about is and isn't jurisdictional. A 12B1 motion is a motion to dismiss for lack of subject matter jurisdiction. As we learned in the first semester of law school, you can't waive the absence of personal jurisdiction, right? It's a speaking motion. It'll be based on fact. What's the citizenship of the parties, etc. If there's no supplemental jurisdiction, there can't be supplemental claims, because if there's no subject matter jurisdiction, there's no state claim that can be attached. And if you dismiss it for lack of jurisdiction, it's without prejudice. Compare that to what's on the right-hand side, which is a 12B6 motion. If it's non-jurisdictional, you can waive it by not raising it. It's going to be based on the pleadings. If you dismiss the case on 12B6, the federal claim, the state claims can stay, and it will be dismissed with prejudice. So why does it matter? We're going to do subject matter jurisdiction first. And if you bring the wrong motion, the court will recharacterize it as a jurisdictional or non-jurisdictional motion. Unless Congress says it's jurisdictional, it's not jurisdictional. So is it jurisdictional is a very important feature in this particular matter. The comedian Stephen Wright said, and I quote, "I spilled spot remover on my dog, and now he's gone." If there's no jurisdiction, the case is gone. So let's talk about getting in and out of federal court in these particular matters, all right? Because it makes a difference if it's a jurisdictional motion. That can be raised at any time. Let's go to our second gold nugget, the missing federal claim. We've got a good example from the Fourth Circuit. We'll come back to that site in a moment. Let's learn the facts. There's a suit against Bayer for damages from a female sterilization device. And the defendant removes it and says, this is a federal question because this drug and this device is regulated by the FDA and subject to the Federal Medical Devices Act. The plaintiff says, there's no federal question here, and makes a motion to remand. Now the question is, do you grant that motion to remand? Here we go. You grant it. There's no federal claim here. The Fourth Circuit held that there's no private right of action under the federal statute. If there's preemption, it's defensive. It's not a federal claim. There's no substantial federal question here. Simply because federal law is hovering around does not mean it's arising under federal law. Take a look at Judge Kobayashi's case set forth in these notes here. Someone had kind of an Amistad claim, and they said there's criminal genocide and there's a federal statute that stops it. There was no private right of action. At most, it was a federal issue. All right. So what's our minor's tip here? Read the complaint. If the cause of action is predicated on a state law claim, the mere fact that federal issues are in the case does not make it a federal question claim. All right. So let's go to our third nugget. The third nugget is diversity jurisdiction. A lot of new things going on here. Let's take a look. So I've got drill, baby, drill. We need to know the citizenship of every defendant. Now, the new judges will tell me, and your judges who've taken my class will tell you, they got to see this screen. Every time someone says it's in federal court due to diversity, you're going to draw a picture like this. And you're going to put the states or nations of citizenship of every plaintiff on one side. And you're going to put the states and nations of every defendant on the other side. If the same state is on both sides of the line, then we're going to have no diversity jurisdiction. Generally speaking, in a non-CAFA case, we need complete diversity. You've got that. But we have to drill. Diversity digging. You talk about mining. How about drilling? You know, my wife, Karen, she thinks I'm nosy. At least that's what she writes in her diary. So here's a case. We had the plaintiff. It was an LLC. As we know, we're going to drill down on an LLC. It's going to take on the citizenship of each of its members. It does not have a principal place of business. It takes on the citizenship of each of its members. And here we had a defendant, and the party did not identify the owners of the LLC. What happened? The Fifth Circuit held there was no diversity jurisdiction, which got raised for the first time on appeal. Courts will sua sponte raise the absence of subject matter jurisdiction, even if it's for the first time on appeal. The court said, and you can see the quote, "We're not happy that jurisdiction's a late show up in this case. Nevertheless, plaintiffs failed to establish diversity jurisdiction." So we need to make sure there's complete diversity. Now take a look on these notes. There's a proposed amendment to Rule 7.1, which is our corporate disclosure form. Normally for purposes of, does the judge have a conflict? Do they know anyone? Are they invested? But because this is a real problem, the new rule, which will probably come into effect in December of this coming year, says that the disclosure statement must also identify the citizenship of every party. So let's do this. Let's do the drilling. I'm a little nosy, remember? So if we have plaintiff from Virginia and we have an LLC, remember, we're going to drill down for the citizenship of each of its members. We're going to keep drilling. So if one of the members of the LLC is an LLP, a limited liability partnership, we're going to drill some more. And we're going to find out that if one of their partners is from Virginia, take a look at the screen, everybody. Virginia's on both sides of the line. We don't have complete diversity. It doesn't matter how much of an interest George Hittner has here. He could have a silent interest, a 1%. So every time there's an LLC, an LLP, an unincorporated association, any non-corporate entity, you have to drill down for ownership. Now, as I said, it doesn't matter how much interest they have. If you're a baseball fan, and that's kind of hard right now in the shutdown, the great Henry Aaron, as you might know, had 755 career home runs. One of his teammates, the light-hitting Ralph Garr, had 3 lifetime home runs. He said, between Henry Aaron and me, we had 758 career home runs. It doesn't matter. You count everybody. Our judges can confirm to us how often this is violated. When we're doing our algebra, we want to look at whose citizenship is which. Individuals are citizens of where they're domiciled. We just looked at artificial entities other than corporations take on the citizenship of each of their members. Corporations take on the citizenship of their principal place of business, which is now defined to be their headquarters, their nerve center. Now, you think it doesn't get interesting? You think we procedure nerds are just nerds? What about a trust? The law has developed in just the last 2 years as to the citizenship of a trust. If it's a business trust, a REIT, a real estate investment trust, then the Supreme Court in Americold held it takes on the citizenship of each of its members. If any of its members are the same citizenship as the opposing side, we've lacked diversity. But what about a traditional trust? The Ninth Circuit has just ruled, consistent with other circuits, that if it's a traditional trust, fiduciary relationship, we only look at the citizenship of the trustee. Now, if you're a nerd, that's because of Rule 17. The trustee is the real party in interest for a traditional fiduciary case. So we have to know. So what is our minor's tip? Our minor's tip is we've got to assess the citizenship of all parties and drill down. Now, I think I've been training the federal judges for now over 30 years, and I've been talking about this drill down approach. They're doing it. But don't get caught. Let's go to our golden nugget number 4. Golden nugget number 4. Is there a removable federal claim? Judge, thank you for that very nice introduction. Let me throw the praise back to you by telling you that this is an example of one of your many cases that was correctly decided. And that goes without saying, of course. Let's figure it out. So we have a suit against a bank for alleged unlawful non-judicial foreclosure and public auction of property on Maui. They bring a claim in state court for unfair and deceptive acts or practices under your code in violation of state public policy, but they also reference the Federal Fair Debt Collection Practices Act and RESPA. We have a lot of federal statutes that came into existence in 2008, and I'm predicting in 2020, that protects people like from foreclosures and loan practices. But they don't necessarily create a cause of action. And even if they do, they don't preempt the state law claims. And if they do preempt, they often don't create their own claim. So here, the state court complaint referenced federal law, it references statutes, but it was a state law claim. Judge, you got it so right. You granted the motion to remand. Although there were federal issues floating around, this was a state law claim. The plaintiff chose to file a state law claim. And there was no substantial federal question under the Grable case. Take a look at some of these cases. It's a trade secret case. And just because it may involve some issues of securities law does not make it a securities law violation case under the 33 Act. We can have a federal trade secret law. They federalized that a couple years ago, but it's not preemptive. The state law trade secret claims can go on independently. Look at the Cornell case. This is a very common example. It comes up a lot in your state. No removal of the state law claim, barring due on sale clauses, just because there's a federal statute that gives some protections. Look at Judge Kobayashi's case there in Goldberg. It was a state court foreclosure action. And the mere fact that we had a defense under the federal statute does not mean it's a federal claim. So there you go. I'm a big Star Wars fan. Plaintiff in state court is the master of the claims they alleged. They're the Jedi master. So if the plaintiff, generally speaking, wants to allege a state law claim, they're permitted to do so, even though they could have alleged a federal claim. You have a claim for employment discrimination under your state law. The fact they could have brought it as a Title VII claim does not make it federal. The fact that there's a state law discrimination or civil rights claim or antitrust claim does not convert it into a federal claim. So if the case gets removed to federal court and there's no federal claim, the federal court is going to remand it unless there's diversity. There's one big gaping rule to keep in mind that's somewhat beyond this presentation. There are some limited areas where federal law completely preempts state law, most notably ERISA and labor law. That is, federal law not only displaces state law claim, it replaces it with a federal claim. That's very rare. ERISA, 301 labor law claims, LMRA, and copyright are our three principal areas. Now, you represent a plaintiff and you brought a federal and state civil rights claim. You just figured you'd be in state court. And as much as you love our federal judges, you want back home to state court. Can you post-removal amend your complaint, drop the federal claim, and get back to state court, if you will, become the Jedi Master and Yoda after the fact? Judge Gilmour's decision here just this year says, as long as you do it early enough and you're in charge of your own complaint, once you eliminate the federal claim, the court has the power and will remand. Therefore, that post-removal amendment, if not done for improper reasons, can give rise to a remand. All right. Now, this is a case from the Supreme Court in just the last few months. We have a retired Catholic school employee sued in Puerto Rico court. That's the equivalent of a state court, of a territory. And it got removed to federal court. While it was in federal court, the Puerto Rico court issued an order regarding payment and seizure. The federal court did conclude it was not a proper case for removal, and it remanded the case. But people kind of like that state court order that was issued while I was in federal court. And so the court did what I just love Latin, a nunc pro tunc judgment. It said, I'm going to remand this case as if it were in state court, supposedly after the fact, giving power to the state court case. Question: is the Puerto Rico court order enforceable? Now, if you've ever been a relay racer, you know all about passing batons. The jurisdictional baton was passed to the federal court. The state court lost jurisdiction, even though it would eventually be reanimated. The Supreme Court held the order was not valid. The Supreme Court said once the notice removal is filed, whether it's good or bad removal, the state court by statute loses power. The jurisdictional baton is handed to the federal court. Until and if it's returned, all of its orders are without jurisdiction. And the court said you can't nunc pro tunc orders. It's not the same as an Orwellian vehicle for revisionist history, creating a fact that never occurred. That is, it was somehow jurisdictionally proper. Most commonly, this comes up when the state court judge says, I know it's in federal court, but it might come back. And so I want you to come in here every 6 months and tell me about what's going on. The court has no power to control the case in any way while it's in federal court. Let's go to gold nugget number 5, a brand new case out of the Ninth Circuit. Bet you didn't know this one. Stirling versus Manasian. A judge in Los Angeles that was decided there was a basis for removal. Let's figure it out. We've got a suit against a JAG lawyer, a federal lawyer in the military, who is licensed not in California, but elsewhere, but they're practicing normally as a JAG lawyer. And another lawyer gets mad at him and brings a suit for declaratory relief and says, you were practicing law without a license in California when you were defending a California Army National Guard member. Let's put to one side whether it's a good suit or a bad suit. That is, a person in federal court may be allowed to practice with a license from somewhere else. Nevertheless, it's a lawsuit. It was filed in state court. It is removed. There's no diversity, and there was no federal question, but it was removed under the federal officer removal statute, section 1442, which allows removal by the United States or any officer or someone who's acting under a federal officer of the United States. Question: should there have been a remand? The court holds that this was a proper removal. Since the defendant was serving both the state and the federal government, the acting under requirement was satisfied. So Manasian was a person per the statute, an officer. There was a nexus between what he was doing as a federal officer and the claims, that is practicing law supposedly without a license. And the defendant was asserting a colorable federal defense, in this case, which is, I have the right to practice in a national system. The court held federal officer removal is sufficiently broad to cover this. Well, wait a minute. When you're removing a case to federal court, what do you have to show? If you're removing on diversity grounds, you've got to show in your notice of removal and then by proof, if you're the removing defendant, that there's complete diversity through the drill down method. Let's figure out what happened here. Rhode Island defendant is sued by an LLC. You're with me now, aren't you? An LLC, we're going to drill down. And it removes the action to federal court. All right. The removal notice says the plaintiff's a Delaware LLC with its principal place of business in New York, and P has no members who are citizens of Rhode Island. Therefore, they say, since I'm from Rhode Island, there's complete diversity. Okay. Sounds pretty good. They're saying, hey, we're from different states. Not a very good drill down. Not very nosy. The First Circuit holds that if there's no diversity, you can't do it this way. The fact is, alleging an LLC's principal place of business and where it's incorporated or created has nothing to do with diversity. They must allege the citizenship of each of its members. And this generic statement of, hey, they're all different than me is not good enough. You must allege the citizenship of each member of this artificial entity that's not a corporation. And you can see these citations when you get these slides about how strict the law is in requiring that as you get in and out of federal court in that particular regard. Therefore, what if the person removing was not that original defendant and maybe not even the original plaintiff? So Citibank brings a state court debt collection action against Jackson. Jackson says, okay, I'm going to defend this suit, but I have a third-party claim that's a class action, and I bring it against Home Depot. Let's assume that class action could be removed under CAFA. There was minimal diversity, over $5 million in controversy. Do we remand this case? I mean, geez, Home Depot has a CAFA case. The United States Supreme Court says, grant the motion to remand. Removal is limited to the original defendants. If plaintiff sues defendant and on a state claim and defendant brings a federal question claim as a counterclaim, that plaintiff can't remove as a general rule unless it's a patent case and an infringement. If it's a CAFA case, it's normally removable. But since this defendant was a third-party defendant, not the original defendant, the Supreme Court in Home Depot said no basis for removal because the statute says defendants can remove. There's a strategy here, everybody. If you want to stop CAFA, let your client be sued on the one-off claim, the claim involving that loan, and then bring your counterclaim or your third-party claim as a class action. So that if you bring it originally as a class action, it's removable under CAFA. If you bring it as a third-party claim or a counterclaim, if they amend the statute, that's not removable. Now, what if we have incomplete diversity, but there's the argument that one of those non-diverse defendants is sham, fraudulently joined? In that situation, everybody, we get this hypothetical right out of the Ninth Circuit this year. The state court wrongful death suit against a care facility and its local administrator, they sue the care facility and the individual administrator for elder abuse. They said you had a bad plan. So the individual local administrator would destroy diversity, but the entity defendant is diverse. So the facility removes, asserting that the individual non-diverse defendant was sham, fraudulently joined. The plaintiff says, wait a minute, they're not sham, and you got to count him, and therefore you remand. How should the court rule? The court will grant the motion to remand. The Grancare case is a very important case for plaintiffs and defendants. So the defendant's removing by trying to press the delete key on the non-diverse defendant, saying they're sham. But you're not sham unless there's no possible basis for recovery. It's not even a 12B6 test. It's even more than that. Here, the court held that the administrator faced some personal liability. There was a colorable claim against the administrator individually for failure to provide due care. This was not a case in which the administrator was fraudulently joined or sham. Therefore, you have to count the citizenship. You remand the case back to state court. Look at these cases from your own district. If an individual non-diverse defendant is not sham, since there could be a commercial seller for liability, the Armstrong case held remand. Judge Otake said that it does not apply to misjoined plaintiffs. The statute only talks about defendants. So if you've got a misjoined plaintiff, we may have to count them. And then the Azad case is another example in which the court held it wasn't sham, there was a possible claim. So every time a defendant removes a case on sham joinder, you want to look at it carefully. So let's do our minors tips. Now, these are not easy, but they're for every case. I call remand Fridays because one judge told me that every Friday she has a little party and they look at all the removals and see if there's any grounds for remand. The top 3 circles, everyone, can be made at any time. There's no federal question jurisdiction, diversity is improper, the shams weren't shams. That goes to the power of the court. Those motions can be made at any time, although make them early. The bottom 4 are procedural defects in removal. And if you have a procedural defect and you want to remand, you must make the motion within 30 days of removal. Maybe all the served defendants didn't join. Maybe there was a local defendant So you've got an out-of-state plaintiff suing a local defendant. The statute says local defendants who are served cannot remove. Maybe there's a waiver, as we'll see in a moment. There's some contract that says you can't remove. Maybe removal is more than 30 days after service. Those bottom four are procedural defects. And you might think that after all the learning we've done, and you're on this panel still with me, you know this stuff. And you'll see judge after judge is issuing orders show cause as to why the case should not be remanded. The comedian Joan Rivers, she was once quoted as saying that you do the housework, you make the beds, you vacuum the living room, and 6 months later you have to do it all over again. Well, look at this screen. Judge Ataki, I share this with you, but it's true of all your colleagues. Why do judges issue orders to show cause on removal? Because when lawyers remove a case and there's no basis for removal, or it's procedurally improper, the judge can raise the issue by an order to show cause. Now, why the rat? Well, trust me, my mama didn't raise a fool. Therefore, the rat is not the judge. The rat is us, the lawyers. The studies all show that rats like to actually be in mazes a lot more than they like to be in open spaces. Right? And this is pre-COVID, but nevertheless, this research still holds, I bet. We lawyers get the guidance from judges like a labyrinth through orders to show cause. If the grounds for remand is lack of subject matter jurisdiction, no diversity, no federal question, that case can be remanded at any time. If the grounds for remand is a procedural defect, while the judge can issue an order to show cause, there must be a motion to remand. No sua sponte motions to remand for procedural defects. So let's go to golden nugget number 6. We've talked about federal question jurisdiction, what I call the front door to federal court. We've talked about diversity jurisdiction, what I call the visitor's door to federal court, over $75,000 in complete diversity. We've talked about removal jurisdiction, the back door. Let's now talk about the side door, or if you will, the pet door, the door within a door, where your pet goes in and out. You've got a federal claimant and you've got a transactionally related state law claim. When will the judge keep jurisdiction over the state law claim? Remember, if we have a jurisdictionally improper federal claim that disappears, the state law claim has to disappear with it. There's no continuing power to hear a supplemental claim if the federal claim was no jurisdiction. But let's suppose, as in this hypothetical from Judge Taki's case, we've got an aircraft inspector who sues an employer for race discrimination and retaliation under federal and state law. So this is not Yoda. The plaintiff is chosen to sue under both state and federal law. So the action is properly removed to federal court. We have a federal claim and a transactionally related state law claim. The state law claim comes through the side door or the pet door. The key to that door is transactional relationship. The judge grants summary judgment for the defendant on all the federal claims, say under the Norr-Pennington Doctrine. So now the federal claims have disappeared for non-jurisdictional grounds, 12b6, Rule 56. Should or can the court retain supplemental jurisdiction over the state law claims? If not, should the court dismiss them or should the court remand? Our judge, of course, did exactly the right thing. The court declined continuing jurisdiction over the supplemental claims and remanded them to state court. After the court eliminated the state law claims, the federal claims on summary judgment, ordinarily, the supplemental claims will be remanded to state court. The court will make exceptions if we're right near trial and there's a lot of judicial resources spent, because the court has power to hear the supplemental claim if it's a summary judgment. And sometimes the court will decide the state law claims at the exact same time. Now take a look at these cases. These are cases that go right with Judge Ataki's decision, which is that says, generally speaking, the court will not retain supplemental claims once they dismiss the federal claims. And if you need to know that, read the Reynolds case for the Ninth Circuit. It suggests it's an abuse of discretion to keep it if it's not too late in the case. So let's go to our minor's tip. Our minor's tip here is going to be, when can the court decline supplemental jurisdiction? Well, here you go. If there's a novel or complex state claim, the court can say, I don't want to hear it. If the federal claim substantially predominates or the state claim substantially predominates, we cannot have the state law claim. Is there some other compelling reason, like maybe the state claim has a jury trial right and the federal claim doesn't? And the one we just looked at, the most common. Once the federal claim is dismissed, the court can decline to continue the exercise, if you will, close the side door. All right. So I've been talking about subject matter jurisdiction, and that's all well and good. But we've now got to deal with personal jurisdiction. Personal jurisdiction. Let's take a look at this fact. And I say it's not the plaintiff, and we'll see why the new law tells us that. So there's a case from the 11th Circuit. Plaintiff was exposed to asbestos 25 years ago while living and working in Massachusetts. The plaintiff then moved to Florida and, right like we see in the TV ads, is diagnosed with mesothelioma and sues Union Carbide for prior exposure and failure to warn. All right. So we're going to have jurisdiction here, subject matter jurisdiction. The question is there personal jurisdiction in Florida over Union Carbide? Let's look at our third column here. Union Carbide is a massive national corporation. It's incorporated in New York. It has its principal place of business in Texas, but look at all of its contacts with Florida. It's registered in Florida to do business. It has an agent for service and process there, a distributor, a plant there, terminals, etc. This plaintiff was exposed to this product while working in Massachusetts, not Florida. Is the motion dismissed for lack of personal jurisdiction be granted? Go in your time machine back to your first year of civil procedure. The court's going to grant this motion. The cause of action did not arise in Florida, but there's no general jurisdiction because Union Carbide is not at home in Florida. It doesn't have its principal place of business there, and it is not incorporated there. So there's no general jurisdiction. Is there specific jurisdiction? Because after all, the plaintiff moved there. And the court said the contacts that are related to Florida are unrelated to this specific cause of action, and therefore, no personal jurisdiction. Does it matter? Oh, hey, everybody, stay with me. This is important. What you have on the screen right now is from International Shoe, right from first year, our amazing case. It's in the top 10. And the Supreme Court held that due process for personal jurisdiction purposes requires the defendant have certain minimum contacts with the forum state, such the maintenance of suit does not offend traditional notions of substantial justice and fair play. Now, my good friend Erwin Chemerinsky, the dean at the Berkeley Law School, said that minimum contacts pretty much describes his high school dating experience. Mine too. But in order to have personal jurisdiction over defendant, that if they're not at home in the forum, requires minimum contacts. The Supreme Court in the last few years has said the mere fact the plaintiff is in the forum, like in our 11th Circuit case, is not enough. In Walden, the court said the plaintiffs were from Nevada, but they were going through the airport in Georgia, and the DEA agent allegedly took their money improperly in violation of their civil rights, and they sued in Nevada. But the Supreme Court said there's no jurisdiction simply because they felt their injuries eventually where they went. Misconduct alleged took place in Georgia. No minimum contacts. Bristol Myers from just 2 years ago. A defective drug that affects, allegedly, this Plavix drug, many thousands of people across the country. And in a lawsuit in California, not a class action, of over 600 people, but over 500 of the plaintiffs weren't from California. The issue of the case was, is there personal jurisdiction over Bristol Myers, which is an East Coast company, albeit doing almost $1 billion of business for other people, over these plaintiffs' claims? Supreme Court said just because the plaintiffs might want to bring it there does not mean there's jurisdiction. The court held no jurisdiction. So you think the law is completely settled? You've got it all down? Are we going to get this one wrong? This case is before the Supreme Court right now, and looks like it's going to be heard, because of this virus, going to be heard next October. Ford Motor Company from Michigan. By the way, everyone, Ford Motor Company is really big. They assembled an Explorer in Kentucky, sold it to a dealership in Washington, state of Washington, and who then sold it to an Oregon resident. It was then purchased and brought by the repurchaser, no direct connection to Ford, to Montana. That's where the accident happened. The plaintiffs bringing the wrongful death suit said, we're suing Ford in Montana, our home state. That's where this particular accident occurred and the alleged products liability. By the way, Ford has a lot of Montana contacts, you might imagine, dealerships and a lot of advertising. They say these Explorers are safe. Is there personal jurisdiction over Ford? After all, the product traveled the stream of commerce foreseeably to Montana. The Supreme Court has granted cert in this case. There's no general jurisdiction because Ford is not principal place of business or incorporated in Montana. So the only question is, what contacts do we count and how related the cause of action they have to be? The contacts for the original purchase was not in Montana. So on the one hand, Ford's saying, we don't have enough contacts with Montana. I don't care how big we are. The impact of this case could be significant. And you can see how we have a case from your district that involves similar issues. When is there personal jurisdiction over large national corporations for things they do allegedly in other states? This case is a big, important case, so stay tuned. Be on top of things. Ben Franklin says, and I'm quoting, when you're done changing, you're done. Don't be done. So what's our tip? When you're analyzing the contacts that relate to this cause of action, treat each contact as a rock. How many products did they sell? Did the accident occur here? Did the company do business with them here? Do they advertise here? Do they have internet connections here? Did they defame someone knowing they were in the forum state? Let's treat those contacts as a rock in a pile. The Supreme Court seems to be telling us in this new age, it better be a high pile. And remember, as a result of these cases, you're going to look at the defendant's connection to the forum, not the mere fact the plaintiff happens to live there. All right. Let's choose a very important gold nugget, number 8. Let's choose, how do we choose the mind we want to be in? Here we have the City of Albany case right out of the Ninth Circuit, and we have the choosing of the mind, right? All right, now forgive me, I have to make one stupid miner's joke, and then we'll go on to a non-pun. Why can you not open a bar in a cave? Because you can't serve alcohol to minors. All right, enough. We've got a contract with a forum selection clause. It says venue for litigation shall be in Lynn County, Oregon. The defendant removes the federal court on the grounds of federal question or diversity, either one, proper subject matter jurisdiction. But is removal waived by the forum selection clause? Do we grant remand because there's no federal courthouse located in Lynn County? Maybe surprising everybody, we're going to grant this motion to remand. This forum selection clause waived the right to remove as long as the motion to remand was brought within 30 days of removal. This is a non-jurisdictional defect. So there was subject matter jurisdiction in this case. But the court held the forum selection clause, which said it had to be brought in a court in the Lynn County, and since there was no federal court located in Lynn County, that was held to be an express and unequivocal waiver of the right to remove. You can do it a lot simpler, everyone. You could have a forum selection clause that says this case we brought exclusively in state court, and it will not be brought in federal court. If that clause exists in a contract that's drafted for your clients, that is a non-removable case. Now look at the Siminoff case, which is distinguishable. There, the forum selection clause said it shall be brought only in courts in King County, and there happened to be a federal court in King County. So it was a court in King County. Ninth Circuit said that's removable. Hey, look at Atoria Dodd, important case, everyone. That's a case that says if one of the defendants who could remove, who otherwise has to join the notice of removal, signed a waiver form and a forum selection clause limiting the state court, nobody can remove. And you can see in your district how your judges, Judge Seabright, Judge Watson, and others are enforcing enforceable forum selection clauses. They're presumptively enforceable. So what this case tells us is that you can not get to federal court if there's a forum selection clause that waives the right. One last thing, and excuse me for being a procedural nerd. As I've told many people, I'm such a nerd that I met my wife 40 years ago in the law school library while she was reading Pennoyer versus Neff. Doesn't get any better than that. That was good enough for me. Civil procedure nerd even then. How about this one, everyone? Let's suppose the clause says it shall be brought exclusively in the courts of Lynn County. Or make it better, let's make it King County. Of. The courts have held the word of means only state courts. In might include federal courts. Of doesn't. Draft your clauses carefully. Minor's tip, always read the forum selection clause. The courts are going to. They'll issue an order to show cause saying, hey, that forum selection clause seems to think, and the judges will be having their remand Fridays, and they'll issue that order to show cause right away, which is an invitation to the plaintiff to make a motion to remand if it's well justified. Remember, the clauses are enforceable presumptively. And, excuse me for this verb, they trump private interests. Or praise me for that verb, depending upon your political persuasion. Let's go to our last gold nugget. Don't look so happy. It's our last one. When can the court act sua sponte? Now, we've learned something already. If the court has no subject matter jurisdiction, it not only should act sua sponte, it must act sua sponte. The phrase sua sponte is in the usage dictionary between the words stymie and subspecies. If lawyers don't know jurisdiction, it is the judge's job to stymie the subspecies of us who are not analyzing subject matter jurisdiction. But what if it's not subject matter jurisdiction? Or the Ninth Circuit just held a few days ago in Adams versus West Marine. So new I don't have a screen on it. Adams versus West Marine, that if the grounds for remand is not jurisdictional, but it is one of those abstention doctrines, in this case a Catholic abstention doctrine, the court may act sua sponte. So the court must act sua sponte for lack of subject matter jurisdiction, may act sua sponte for an abstention doctrine. What about personal jurisdiction that can be waived? Venue that can be waived? Affirmative defenses that can be waived? Let's take a look at this last fun case from just a few days ago in the U.S. Supreme Court. The party in a criminal case raises the challenge to a statute as vague and does not challenge it for overbreadth. The Ninth Circuit, thinking there's a problem with the statute involving whether someone can be criminally punished for advocating things for immigrants and allegedly illegally, sua sponte calls for amicus briefs on overbreadth. Remember, that's the argument that was not raised in trial court. Question: should the court have inserted arguments not made by either of the parties? That is, act sua sponte. Remember, this is not jurisdictional. This is an argument. The court says we're reversing. The courts cannot take over the job of the lawyers when it comes to these kind of issues to raise. Now, you might say this is just an appellate doctrine. You waive arguments you don't raise in trial court. Fair enough. But the court has much broader language in a unanimous decision written by Justice Ginsburg. In good health, I'm sure. In both civil and criminal cases, we rely on the parties to frame the issue for decision and assign to the courts the role of neutral arbiter of matters the parties present. The court should not have engaged in a radical transformation in this case. It goes well beyond the pale. What does this case mean? I think this case at least supports the proposition that if defenses or issues are waivable, the courts, generally speaking, are not supposed to insert themselves and make them. It does not mean the court won't have ideas about discovery. It doesn't mean the court won't have ideas about how to manage the case. It doesn't mean the court won't sua sponte remand or even suggest a remand with an order to show cause to we rats. It means, however, though, that something like an affirmative defense of statute of limitations, if it's not presented, it's waived. And so if you have a case in which the party has waived something, the Singh case, which says in both civil and criminal cases, might be a good citation. All right. So I guess my practice pointer on that one, the minor tip is make sure you think of all the things you have in that particular regard. It doesn't always work. Now, people have always asked me, what are my top 10 cases? At the end of each semester, everybody, I give to my students a little plastic card. It's called my top 10 cases of all time civil procedure. That's pretty nerdy. Put it in my wallet. And when I see my students later, they often pull it out. Number one case of all time, Erie Railroad versus Tompkins. Celotex, our summary judgment case. International Shoe. Hickman versus Taylor, our case involving work product doctrine. Of course, Twombly-Iqbal or Twickball. Hansberry versus Lee, the great predecessor to class actions. Penoyer, because I met Karen while I was reading it. Motley, because it talks about federal defenses don't equal federal jurisdiction. Gibbs for supplemental jurisdiction. And Atlantic Marine for forum selection clauses. That's my top 10. You might have yours. I'm happy to discuss it with you because I'm a weird minor. I believe in these things. The great writer E.B. White said, be obscure clearly. I hope we've been obscure clearly with these matters. Let me quote from my favorite poet, T.S. Eliot, who said, and I quote, "We shall not cease from exploration. At the end of all our exploring will be to arrive where we started and know the place for the first time." Well, you've heard these doctrines before, but you know it again for the first time because you know, everybody, there's new cases that come down all the time, and you can stay on top of these matters and get it right. Thanks for spending an hour with me on jurisdiction. I know if there's any questions, Steve can coordinate that. And thanks again, everybody, for doing a little mining with me. Feel free to use my practice guide. It's available online and in book form. And if you're really a nerd, follow me on Twitter. I have a civil procedure tweet every day. Thanks, Steve.
Thank you, Professor. We do have a number of questions, in fact, but I think we only have time for a few. The first question has to do with whether or not you have a prediction for the Ford Motor Company case before the Supreme Court, predictably this October.
That's great. I like prediction questions when I'm on tape. All right, I'm going out on a limb. The Supreme Court's going to find no jurisdiction. They seem to be on a roll here of saying that big companies only have to defend themselves in the states where they actually are existing or where they caused the injury. So I predict no jurisdiction, 5-4.
Okay, so unfortunately, that is all the time we have for today. As a reminder, the FBA will email the slides for today's presentation. On behalf of the Hawaii chapter of the Federal Bar Association, I'd like to first thank Judge Ataki for recommending Professor Wagstaffe. The FBA would also like to thank Professor Wagstaffe for sharing his insights on federal jurisdiction. It sounds like it will be a big, important year for federal jurisdiction and for 1L civil procedure students everywhere.